Okay. Recording.
All right. Good afternoon, everybody. Thank you for joining us. We don't have too many people here in person, but I think we have a good audience online. So thank you so much, everybody, for being here and for participating. So this afternoon, we have a great topic about guardianship. We have 4 really strong panel members to kind of discuss some of the challenges in guardianships, as well as solutions and things to moving forward and how to address the problems that exist. The first panel member is Angelica Heaton. She has extensive risk management experience, has been a results-oriented risk and claims professional with expertise in organizing and executing programs to mitigate and control risks associated with patient care services. She was most recently the director of risk management at the University of Washington Valley Medical Center and just joined the risk management team at Providence Swedish Medical Center in Seattle. So welcome, Angie. Christina DeVete is of counsel at Ogden, Murphy & Wallace in Wenatchee. Her practice is focused on guardianships, representing hospitals and healthcare entities, professional and lay guardians, as well as estate planning and probate. She is a certified professional guardian and a Title XI guardian ad litem. Prior to obtaining her law degree at Seton Hall University, she practiced as a geriatric nurse practitioner and is a co-author of the text Case Studies in Geriatric Medicine. Welcome, Christina. Thank you. The third panel member is Kim Cummins. Kim has worked in the healthcare field since 1994. Her experience spans a continuum, including ambulatory clinic services, hospital care, behavioral health services for both adults and children. Kim has a master's degree in health law from Loyola University of Chicago and a Bachelor of Science in Rehabilitation Counseling from the LSU School of Allied Health. Throughout her career, she has been recognized as a successful and dynamic leader, collaborator, and influencer and change agent, as well as expert problem solver. Kim is certified in lean in health care from the University of Michigan School of Engineering. She's also a certified professional in healthcare quality. Kim has been an integral member of executive leadership teams and advisory boards throughout her career. Based on a widely known reputation for advanced knowledge, skills, and results, Kim was sought after and hired as an expert consultant for assessing organizational performance and developing and implementing strategic plans, providing leadership coaching, developing staff, and implementing performance compliance systems at several organizations. She has successfully led the following departments throughout her career: care management, social work, performance measurement, utilization review, patient experience, staff development, health information management, and corporate compliance. Currently, Kim is the executive director of the Care Continuum for Multi-Care Health System Puget Sound region. Welcome, Kim. And Heath Fox is also a panel member this afternoon, and he's also going to be a moderator of sorts. So he'll be in charge of the clicker. Heath is a dedicated defender of healthcare professionals. For nearly 2 decades, Heath has focused his civil litigation practice on the defense of claims against hospitals, physicians, nurses, long-term care facilities, and other healthcare professionals. He has extensive experience in licensing matters for healthcare providers and consults on healthcare law and guardianship issues. Heath has obtained favorable jury verdicts in cases involving wrongful death, surgical complications,
I'm just on the whatchamacallit. What's up?
And other permanent disabilities and alleged never events. He also volunteers as an attorney mentor, board member, and volunteer coordinator for the Washington Medical Legal Partnership, dedicated to helping people in vulnerable populations during times of crises. Welcome, Heath. And again, thank you everybody for participating, for being a part of this. If you are online or on the phone, we do ask that you mute your end until the question and answer period. In that time, we're going to open it up so everybody can have some questions. But thank you very much, and I turn it over to the panel and to Heath.
Everyone can speak loudly here. This way you can all hear it. All right.
Thanks, Mike. Just to give everyone a fair warning, we had decided to carve up our spots today as follows. I'll give a kind of a quick Guardianship 101 overview for people who are a little newer to that process. Then Kim's going to talk about some of the demographics and numbers that are behind this silver tsunami that's really bringing guardianship into a larger role in our state, probably across the country, but definitely here. Christina is going to talk about some of the differences between Eastern Washington and Western Washington for guardianship. And she would certainly know, having served as a guardian and counsel for hospitals. And Angie Heaton will talk about roles, and in particular the role of risk manager interfacing with social work staff, outside counsel, et cetera. And then we'll open it up for questions. So if you're asking why are we bothering to talk about guardianship, isn't this the Washington Healthcare Risk Management Society? Aren't we medical malpractice defense people and claims managers and risk managers? What does guardianship have to do with any of this? Has anyone heard the phrase length of stay?
Every day.
Or maybe difficult discharge? And I wonder maybe if we can unmute people in case people have questions during the lecture, so it's more interactive.
You bet.
Because I have a feeling some people have some powerful experiences related to these kinds of issues.
Mm-hmm.
Anyway, before I started explaining some of the law about guardianship, do you mind?
Yeah, I'm gonna switch them back. There you go.
I wanted to talk a little bit about why we need guardians in the first place, and going all the way back to the bedrock of our legal system. So much of it is based around the idea that we all have personal autonomy. What does that mean, personal autonomy? Kind of baked into that phrase is the idea that we all have rational decision-making abilities, that we should be in charge of our own destiny, that we should be in control of what happens to us, including our bodies. And that idea has been thoroughly embraced in our legal culture and our culture more broadly. And when you come to the hospital, you get given a bunch of consent forms because no one's allowed to do things to you without your consent. And that's supported across the board. Our Constitution's been interpreted to uphold that idea of personal autonomy. We have case law around that, and we have statutory protections for that. So, as probably all of you know, that can create some issues in the healthcare arena. So what do you do if you have a patient who's about to die because they need that emergency appendectomy, they've got a hot abdomen, the surgeon says, I need to get in there and solve this problem to save your life. But the patient doesn't want the surgery. What do you do? Well, if they have capacity, they get to choose. They can choose to die. You can't force that surgery on them. But it gets a little more complicated when we explore the idea around consent for the surgery. You know, when is it required? Who can give it? What for? What if that patient who needs that life-saving surgery doesn't quite understand all the risks that are being discussed? Can they provide informed consent for the surgery?
Are they material risks?
Good question, yeah. Do they need to be able to understand all the minutia or just the material risks? So I think those issues create problems when you're talking about life and death situations in the hospital. And if you have a patient who desperately needs some life-saving care, and there's a question about whether they have decisional capacity such that they could refuse that by right, or do we have an obligation to follow up on this capacity question to see, is there something else we can do to help them get the care they need? Are we obligated either legally or ethically to get them that care because they don't have the ability to really make that decision for themselves? So what is capacity? How do we define it? I get that question a lot, and in the law, it's a little different than I think most physicians interpret that in the hospital setting. In the hospital, they talk about decisional capacity for healthcare founded in medical ethics principles. In the law, it's maybe a little vaguer and maybe not quite so moment-to-moment situational. It can actually be judged over your track record over a period of time. You have a demonstrated track record of putting yourself at significant risk based on a demonstrated inability to adequately provide for your health, nutrition, safety, care for your finances. So that broader definition, I think it can be helpful in the healthcare context when we're really concerned that something terrible is going to happen because someone doesn't quite have the wherewithal to understand their situation, but maybe they can kind of understand a lot of what's going on. You may have a physician who thinks, I think this patient is kind of decisional, but a judge might disagree and say, no, this person does not have capacity. So it's a different standard. Now, when we decide that a patient lacks decisional capacity in the healthcare setting, so we're concerned that they're not going to be able to consent to care they need or appropriately refuse care if that was their choice or their preference. And obviously, we always want to start from the proposition of autonomy and respect patient wishes first and foremost. Who do we turn to for the patient who doesn't have capacity? We need a legal surrogate if we want to be on the right side of the law and enjoy the protections, the presumptions in Chapter 770 RCW. This is the old list I have here, and it's in descending order of priority. So any appointed guardian trumps another family member. Power of attorney trumps the spouse even, surprisingly. Children, parents, siblings. That is kind of restrictive because a lot of people don't have someone that fits one of those categories to help them out if they end up in the hospital without decisional capacity. Thankfully, this law has recently been amended and broadened, and I'm sure Kim can talk more about this too, but a whole lot of new people are now added to the list. Grandchildren, if they're adults, nieces and nephews, aunts, uncles, or really any adult who's willing to swear to certain conditions regarding their relationship with the patient. So this is a huge expansion of the legal surrogate statute. I think it's going to be incredibly helpful for the majority of patients who don't have someone who fit the original category. And it may lead to some litigation down the road when we have to kind of fight about who's allowed to speak for this patient. So you have two friends, two roommates. It wouldn't have fit under the old statute, but they're both willing to fill out a declaration under the new statute. And they have different ideas about end-of-life decision-making. They have different ideas about what the patient would have wanted. Some of those may need to be resolved in the court, but I think that's a nice problem to have compared to how it was before, where it was always a struggle to find a legal surrogate, and so many patients were just left hanging because they didn't have it. I think this is going to be a big plus. Now, what do you do if you can't even find someone under the new statute to be a legal surrogate? You have a patient who doesn't have anyone who can provide any legal consent for them. Maybe they need some life-saving care or even routine care. You want to provide that. It's medically, ethically appropriate and maybe required that you at least offer that care. But there's no legal surrogate out there. Guardianship is a last resort. It strips someone of their rights, their legal rights to autonomy. So it's something that you want to do after you've explored all the other less restrictive alternatives. But it is sometimes necessary, and as Kim can talk about the demographics coming our way, it's going to be increasingly necessary for a lot of our patients. There's a legal process set out in the statutory framework in Washington's Chapter 1188, 1192. That, by the way, is set to change in 2021 under the new Uniform Guardianship Act. That's still getting tweaked. Right now, those tweaks are getting hammered out in the legislature, so what's on the books today may change before it actually becomes law. So I wouldn't spend a whole lot of time trying to learn the new law yet, because it's probably going to change on us. In the current law, we have due process in the form of a petition that's filed with the court. The court will appoint a guardian ad litem. There's a lot of confusion around what a guardian ad litem is, because it sounds a lot like guardian. Probably everyone who serves as a guardian ad litem gets about 100 phone calls per case from healthcare providers who think that they're the actual guardian. And the difference is a guardian ad litem is just a temporary court investigator, not a true permanent decision maker like a guardian. So that nomenclature throws people off. In the new statute, that nomenclature has been changed to try to avoid that confusion. We'll see if that change survives.
What's it changed to?
I think it's called a court visitor.
Oh.
Huh.
So visitation, that has a lot of meaning depending on how you interpret that word. I'm not sure it's going to be all that helpful, but it is different. It's a lot different than the word guardian. So
Yeah.
instead of confusing it with guardian, it'll be confused with something maybe less helpful. You do need to be careful to provide notice, obtain a proper med psych report that conforms with statutory guidelines, and then make your way to a hearing after all the due process concerns have been addressed. And then just some tips for hospital-initiated guardianships. I wouldn't stall out your case. If the patient has an urgent need, don't wait 2 months to get your case rolling because you have one factual question or something on your petition template that doesn't have an answer. If there's a real need, you should just get that ball rolling, and you'll.
Whoever just. Okay then. All right. Muting all the people. Sorry, everyone. You are now all muted until further notice. Text, press something on the chat if you have any questions or you want to speak, I guess. Otherwise, keep going.
Okay. If you've got a really tricky case that requires some special expertise, like maybe your patient needs electroconvulsive therapy, or you're in a jurisdiction with a limited pool of guardian ad litems, and only some of them are willing to take on end-of-life issues, something like that, there is room in the statutory framework to deviate from whoever's next on the list from the guardianship registry, and you can make your case to the court as to why you want to handpick a guardian ad litem for a specific job. But you have to get something on the record if you're going to do that. For notice, we always have the patient personally served with the paperwork, and then we also mail copies to all identified family members, because the last thing you want to do is get all the way to a hearing and then have a family member come in with a last-minute objection and a notice complaint, because the court would almost always postpone your case, and maybe that patient can't afford to wait another 2 weeks for notice. So take care of notice up front. There's a lot of confusion around who needs to fill out the med psych report in the world of guardianship. A lot of people think it needs to be a psychiatrist or a psychologist or maybe a neurologist, someone with special expertise in assessing mental capacity. But under the law, that's really not required. Anyone with an MD, PA, ARNP behind their name, maybe even a licensed clinical psychologist, could fill out that form. And the real key is that they've seen the patient within 30 days of completing their report. If it's 35 days, the court may say, I'm sorry, that's not compliant. You need to get a new updated report. And I think the biggest takeaway for hospital-initiated guardianships is don't push off that hearing or let other lawyers in the process push it off infinitum for their scheduling convenience or some other reason. I would focus on what does this patient need, what is the problem that needs to be solved, and drive that process forward. And it's okay to be a little pushy, because in the world of guardianship, I think a lot of lawyers who come up in that side of the law are used to moving at a different pace, certainly not the pace of healthcare. And they may need to be pushed a little bit to understand that there are some more urgent needs that are usually behind these hospital-initiated guardianships. And Noah, you have, for good reason I know, disabled this clicker. Good. Another big thing that I've seen in some other hospital-initiated cases is the idea that until we have a guardian appointed, there's really nothing we can do. We just have to wait for that process to run its course. I see Christina shaking her head violently. And she can explain how in Eastern Washington, how good they are routinely addressing adjunctive relief from the get-go. And that should be the goal in whatever jurisdiction you're in, because that patient shouldn't have to wait 45 to 60 days to get relief. Usually there's an urgent problem that needs a resolution. And I would put the patient's needs first over the convenience of counsel or whatever else may suggest that something should be delayed. And in my experience, the courts have been very sympathetic and helpful as long as you make that case to them. The courts are rarely the bottleneck. It's more the players who get assigned to your case, and there's a wide range of personalities and philosophies around guardianship that you have to navigate. So I would encourage people to work with those individuals to help them see your side of it and why this patient may need help sooner than later. And then also, just because you've started a guardianship doesn't mean you're locked into that path. If there's improvement, if the patient does better than expected, that's great. You don't have to take it all the way to appointment of a guardian if it doesn't seem like it's appropriate any longer. So you haven't locked yourself into any particular path simply by starting this. It's very easy to dismiss the case or to resolve it with a less restrictive alternative, and usually that's great news. So I think those are all my tips, and next up is Kim Cummins.
Hi. Just wanted to share from the hospital some information that has been on our strategic plan in terms of how we're going to prepare for the silver tsunami, if you will. The Census Bureau is reporting that the oldest of the old will be upon us very soon. In fact, in the next 2 decades, older adults will outnumber children. And so we are, this problem's not going to go away, because for the oldest of the old, they will have outlived all of their relatives and likely their friends and neighbors that, potentially who might want to take care of them. So this is going to be a problem, a bigger problem than it is right now. And for those of you who work in hospitals know that we're full. We seem to be always full now. We used to have a nice little breather in the summer, but we've even been in surge capacity during the summers now. So there's not a lot of capacity in the hospital for people to just sit and wait for services. And guardianship is one of the list of top 3 or 4 types of community-based services that take really that are very slow, take a long time, and cause people to become what we may appropriately label difficult to discharge. It's really not the patient's problem, it's a resource problem. I wanted to share some other statistics that I think are really important as well. In the last 6 months of life, that is when most people use the most of their healthcare resources. Is pretty significant how high. It's disproportionate to the rest of someone's life, how much hospitalization and healthcare a person accesses in the last 6 months of life. And there are other gaps in healthcare, and guardianship and decision-making is a piece of it. But we aren't trying to touch that decision-making question at every point that someone accesses care. So even when, because I did a survey in Pierce County on this, when someone is placed in an assisted living facility or an adult family home or even a skilled nursing facility or a nursing home, if at that time they have capacity, there's a very inconsistent practice. It's in their rules or it might be in their policies, but it's a very inconsistent practice that they will say to that person, who would you want to be your decision maker? And often what happens for us is someone might be in an adult family home for years, with homeowners that really care about them and take care of them, but they have progressively worsened and get to a point where they do not have decision-making capacity and wind up in the emergency department for a medical condition or a fall or an injury or UTI, and they don't have capacity, and the family homeowner can't speak for them, and we, without a guardian, need to potentially pursue that information. We do try to exhaust every resource that we have. Caseworkers that may have placed them in the adult family home, but oftentimes those state and local agencies, their paperwork is not always up to date either. This increase in age is going to be a problem. We also aren't good in healthcare at asking people about what their goals of care are. And we have a tendency, because of those folks who go into medicine do it because they want to treat, we sometimes have a tendency to overtreat. So without a decision maker or someone who can be there to advocate on the patient's behalf, we are doing a lot to people that they may not have wanted or that isn't even really appropriate or necessary. So this is a big problem, and it's impacting all of our healthcare as the rising costs of healthcare really impact the availability of services and what's going to be paid and covered. This is a piece of that pie, and we need to be really thinking about that. There are definitely downsides for the patient, for the healthcare system, for the hospital when someone has a protracted length of stay, as you mentioned. You don't want to be in the hospital if you don't have to. It's not a great place to be. There's a lot of other diseases and infections floating around. You're laying in a bed, people become debilitated. They have what we call hospital-acquired disability, because a hospital is designed to treat something acute, get people back to a level where they can move on. And so we don't have recreational services. Occupational and physical therapy is intermittent. It's really just for assessment. It's not for actual therapy. And so people who stay there longer than they should most often get worse. And then if you add in layers of things that are reasons why they might stay there, like dementia, which can lead to delirium, fall risk, if someone has a mental illness and they're on psychotropic medications, they're already at a higher risk for falls. That's a normal side effect of those medications. And so there's risk for injury to them and injury to healthcare workers, and as I said before, potentially unwanted care. It's a poor use of an important resource that our community needs, and more often than not now, people are waiting in the emergency department for half a day, sometimes even a day, just to get admitted, because we have beds, 10% of the beds, 5% of the beds, depending on the hospital in the area and the state, that have people in them. Really, it's more like a residential bed, not a hospital bed. And so we can't control our back door, we can't control our front door, and it's really a poor use of an important resource. So it slows down that throughput and admissions for sicker patients. And we do see employee injuries go up in healthcare. And more than that, to me, is the demoralization that the nurses and the physicians feel because they are just so dissatisfied that they have a patient in front of them they don't know how to care for, because it's not what they were trained to do. So if someone is there because of dementia and they're combative, they're wandering, they're not safe, it's not a locked environment. Can't be, and so there's just a lot of factors that make it hard to care for someone who's in this situation, and it really is demoralizing for the clinicians as well. And we have more resource constraints coming. So just in the last 2 years, we've had at least 16 nursing homes closed. Their funding has been reduced significantly. There is a change that just started this month in the payment models for skilled nursing beds. They will receive a little bit higher rate, but they will be focusing more on medical acuity and not on physical therapy. So your older adult who had a fracture and a fall, who lives at home alone, is a patient we used to send to a skilled nursing facility. That's probably not going to happen in the future. And so as things happen with that, someone who's aging and more falls, maybe a head injury or ongoing dementia, increasing problems there, we're going to see more lack of resources for that population. We are not good at helping people age in place, and that's a problem in the state. We have defaulted to placement in facilities for a long time. We have a high proportion of placements out of hospitals, and we do not feel comfortable as clinicians sending people home, which goes back to your comment about autonomy. I don't want to be in a nursing home. I don't care if I'm 75 and my house has stairs. If I have capacity, I want to go home. So, because there's different risks in the nursing homes. So, but we do have a tendency to influence people to choose placement, and those options are going to go away anyway. And there aren't a lot of other resources to shore up that disposition. And so our physicians and sometimes our nurses, even our care managers and social workers are reluctant to support that discharge plan. So without those decision makers in that support system, this is going to continue to be a problem. So I did put some links in here with some resources about the nursing home closing, the information about the Census Bureau statistics. So we are working to try and expand our outpatient palliative care, outpatient therapy. We are partnering with the state in the Honoring Choices program, and next year bringing in folks from CAPC, which is the California Palliative Care Association, to be with all of our primary care providers, to do training for them on how to actually have these conversations about goals of care, and make that sort of a requirement for certain diagnoses and conditions so that we can get better at documenting what the patient wants before they get to a point when they can't tell us. And I think that's really going to need to be a bigger movement than it is in healthcare if we're going to be ahead of this curve with the way the population is aging. Is it a lot fewer slides? Thank you.
I can stand here, yes, hi.
You got
So yeah, I'm a certified professional guardian at the Murphy Wallace in our Wenatchee office. We also have a mothership here in Seattle where we have a deep bench of attorneys that do healthcare and what, so happy to be here. Thank you for asking me. So Heath and Michael asked me to talk about what are the differences in Eastern Washington that I see. Well, we are Chelan, Douglas County primarily. We also reach into Okanagan and Grant. And so Chelan, Douglas, we have 20,000 people age 65 and over, which doesn't sound like a lot, but it is for us. And the Alzheimer's Association estimates that now 10% of people 65 and over, and as we know, 50% of those age 85 and over have dementia. And we know that 85 and up is the fastest growing age group, so there's the problem she was talking about. So basically, currently, 2,000 people in Chelan and Douglas counties have dementia, which is a lot for us. And if the statistics for our counties run with the country, and 0.4% of the adult population is under guardianship, that would be about 500 active guardianships in our two counties at any one time, which doesn't sound like a lot until you find out that we cover an area the size of the state of Maryland. And how many CPGs are there in Chelan, Douglas, Grant, and Okanagan? 6. There's 1 in Okanagan and there's 5 in Chelan, Douglas. 2 of the guardians, 2 of the CPGs have full-time jobs. 1 is a CPA and 1 is an attorney. Now, fortunately, the Office of Public Guardianship really recently got some funding to help fund guardianships and CPGs in Eastern Washington, but that depends upon having CPGs available. So that's a challenge for us. So the good, the bad, and the ugly about Eastern Washington guardianships. So the other thing about, back to the slide about state of Maryland is we have really, and aging, is we have really become a retirement community, a really retirement base for people from Seattle, from the west side, or the wet side as we call it, who are tired of working for Boeing and Amazon and being in the rain, and they come over to the sun. And the other challenge is that their families often live still here on the west side or on the east coast. So we have a lot of unsupervised old people who are now getting demented. So that's a bigger challenge for us. So good, bad, and ugly about Chelan, Douglas, and this Eastern Washington. There's not many people doing guardianship work. There are not many GALs, and we have close working relationships in the guardianship bar. We trust and can generally depend on each other. I started a coffee and cases, so once a month we meet, just a bunch of us, and talk about different cases and different challenges. So we've started to, we have a brain trust now that we can say, you know, hey guys, you know, I have this problem, what do you think? So we generally can depend on each other. And generally I find that people value relationship above $1. So, because the problem is that if I am nasty to you in a case, 2 months from now, I'm going to be working with you again. So I better be nice. And I will also see you in Costco on Saturday or any other place I might go. It's a very small town. Okay, so one other good thing is it's the culture out there fosters an independent spirit. But the bad thing is, the culture fosters an independent spirit. Back to the autonomy that Michael was talking about, the good thing about it is that the independent spirit means that the judiciary is more likely to give me something that I want for a hospital or for a guardianship that's a little bit outside the box, because there's this independent, let's think, let's figure it out kind of thing. But the other problem is it's more like the Wild West. It's like, yeah, we have a couple of cases from our hospitals where it's grandma with guns, grandpa with guns, or grandpa with guns and wife is demented, running down the street, no clothes, and he says, you can't touch my woman, that's my property. And so that's a challenge. What do we do when he has the power of attorney and it's not working? So that's where guardianship kind of comes in. But grandma and grandpa with guns are big problems for us.
Wow.
It's not. I got a call on a Sunday night from the GAL. I was the attorney for the AIP to say that the cops were at the AIP's house because she was threatening to kill the GAL with her gun. So we all made it through, but yeah, it wasn't easy. Okay. The other thing about the independent spirit is Washington, I moved here from New Jersey in 2009, so 10 years ago, and it seemed to me that it was much more independent. And part of the law in Washington is I can't, even under a guardianship, make someone move to an assisted living or a nursing home. So it's kind of like a rot in your house kind of law. Like you can stay there, you can stay there. So how do we get the people out of their houses and into the facility where they're safe? So it's a big challenge. Okay. So also in Chelan, Douglas County, we have a small judicial bench. We have one judge in Douglas, we have 3 in Chelan. So you get to know them and they get to know you, which is good. So it's easier to get things done. So Heath asked me about injunctive relief. So my petitions, if the person's in the hospital, if the hospital petition, my petitions always say the GAL can move them to an assisted living or other appropriate facility as long as the GAL determines it's in their best interest and no other reason justifies delay. So yes, the patients get out of the hospital, which saves everybody money. And as Kim says, if we can't control the back door, we can't let people in the front door. So this is a way of moving things ahead, which is good. And so it's easier to get things done. There's a small bar, there's a small guardian ad litem cadre. There's probably 10 of us, if that, in each of the 2 counties. In fact, the court administrator is now kind of on vacation in one of these counties, and it was like, well, who's on the list? And we don't know. Well, call who you know, which is not the right way to do it, but that's what we have to do. Okay. The good thing about our county is that the GALs can get $65 an hour for a county pay case, and in King it's $35. But still, it's a very small bar with that. Some of the kinds of injunctive reliefs that I've been able to get are, petition for additional GAL authority. So, man who was living in a homeless shelter for 50 years, saved his money, had $80,000 in the bank. So instead of the hospital having to pay the first 2 months or whatever months in the assisted living, I was able to get the GAL authority to pay for his care until a guardian was appointed. So that was helpful. That saves money for the hospital. We get them discharged earlier. And I also get additional authority for the GAL to sign off on a Medicaid application or a DDA application, or however we're going to get them services. And that's because we know each other and we trust each other. And I wouldn't ask a GAL to do something I don't think is right. Now, the bad and the ugly about this is that we have fewer resources for placement. We have a couple of nursing homes. We have a couple of adult family homes. There are very many fewer GALs, and of course there are very fewer CPGs. And so all our CPGs are full, and I've taken to looking outside of county at a CPG. I've also taken to looking at cases and say, okay, this is the patient. He's a 79-year-old guy with dementia who's a veteran, blah, blah, blah. What kind of a guardian does he need? And thinking about all the people I know and who would match that. And so we've started to go out into our personal circles, because a person could be a lay guardian for 2 people. So I recently had one of my attorney buddies say, look, I have a guy who's a bookkeeper who's looking to get into guardianship. And so I got him a simple case of a gentleman in the nursing home who doesn't need much, and we'll train him, and the hospital will pay me to work with him. And so we get him a lay guardian, a good one, and then I'll get him a second one. And then we keep moving on to, who do I know, and who do you know, and who can we tap? Who's a reasonable adult, over 18, not a felon, that we can get to be. And that's how we do it, because I don't have any way to train up CPGs myself. So the other challenge is that with a young bench, and some of them are recently, I had a trial this summer, and the judge said to me, Ms. Davitt, this is my first guardianship hearing. What statute are we in? Okay, Your Honor, let's do this. And so the bench is getting up to speed. Now, the challenge for that is, A, you have to teach the judge, but B, you have to make sure you're doing the right thing, because the judge is not going to know if you're not doing the right thing. So you really have to be on guard to make sure you're doing everything exactly right and be obvious about what you want. And there's no language that they understand yet. Like when I stood up as the attorney for the alleged incapacitated person and said, Your Honor, I am here to advocate for my client's position. He doesn't get that I don't really believe what she's saying. I think she needs a guardian. And so he goes and enters a limited guardianship fee. So I have to be more obvious about it. Okay. So I was talking to some of my clients and said, so what else can I say about, what else would you like to know? She said, well, what about solutions? I said, okay, so solutions for me and with the hospitals I work with is focusing on clear procedures. Obviously, early identification of the alleged incapacitated person. As they say, don't wait 2 months to get your case done and then yell at me when the person's still in the hospital. But early identification, so that takes training. Training of social workers, case managers, physicians, from the door, do you have a decision maker? Where are you going? Basically, kind of questions. And training as to who needs guardianship. Clear communication, and then a standard set of records that I want. So I was a geriatric nurse practitioner before law school, so I am happy to read a medical file. So I don't want everything, but I have a standard set that when I say to the hospital, I want the records, they will send me exactly what I want, which is good. And if I want more, I can get more because we know each other. It's easy. Okay. And most importantly, intentionally work on having good relationships between yourself, between outside counsel, between the social workers. We're all in this together to help people get organized and get on the right path. Okay, but intentionally working on good relationships, because I can always get more money. I can't get more GALs. I can't get more guardians unless I make them. So intentionally working on good relationships is what really is the key to my practice to working with hospitals. And thank you.
Great.
Hi, thank you. Thank you for inviting me. I'm excited to be here. I suspect that the reason that Michael and Keith invited me to participate here today is because when I was the director at Valley Medical Center, I worked a lot with Keith on guardianships, and we worked closely with our social workers at Valley Medical Center in regard to guardianships. And I've only been with Swedish for 2 months, so I am still familiarizing myself with their process. So I'm probably going to be leaning a little bit more toward my experience when I was at Valley Medical Center. And what I was asked to talk about today was to help you understand some of risk management's role in the guardianship process, how risk helps to guide the determination process with care providers, social workers, and case managers, and how we work with outside counsel when we need to seek a guardianship, and what are some of the key challenges that are faced by the risk managers in the risk management department.
Way forward from that.
Sorry.
Let me see. I'm trying to make sure we're in the right spot here. There we go. Good.
I'm trying to get past the objectives page to the guardianship page. It's not working.
Clicking now. Next one.
There we go. Sorry about that. So So when we're looking at guardianship from a risk management perspective, we're looking at it to determine what's in the best interest of the patient. So risk management's role is to consult with the caregivers, the social workers, and the case managers to help them come to a decision regarding the guardianship. And our role is to advocate for the least restrictive alternative to guardianship. Sometimes I know that Christina was talking about, have an early awareness of when a guardianship is necessary to start the guardianship process. But I have found in my experience, sometimes we start a little bit too early in the process and we haven't gone through, really kind of vetting it, what that process is. And so what the risk gathers information to help guide decisions. We focus on what's in the best interest of the patient. We try to understand what's the story for this patient, what are the treatment plans, what's the plan for discharge and transfer. And again, we want to make sure that it's focused on medical decision-making and clinical assessment of capacity so that we know that it's about the informed consent that needs to happen for the care of the patient. And that and we want to make sure that it's not based on other considerations, which I'll touch on a little bit later. And then sometimes we have to also recognize where's the request for the guardianship coming from. Sometimes the patient may have capacity or maybe on the edge of capacity, but they have family members, they have next of kin, they have surrogate decision makers that are in place. But what I have found in sometimes in a hospital setting is that there's sometimes a pressure from outside agencies to have the hospital front the expense for the guardianship. And so we've had a struggle with that occasionally because you're motivated to help discharge this patient, but say the SNF tells the family member, well, your loved one is not going to be able to come here unless you have a guardianship. The family member doesn't necessarily have the resources to be able to go forward for the guardianship. So then you have to kind of balance out what's in the best interest of the patient in that role. And so that can be an interesting a little bit of dilemma to balance that out as to whether or not you want to take on that expense when it's really not an expense that we have to take on. I would say if it's in the best interest of this patient, sometimes we do.
But it's in the best interest of the hospital.
Yeah, in the best interest of the hospital
Right.
as well. Yeah, exactly. And so one of the things that, as we gather information, we also want to understand the description of the nature and the extent of the limitations that the patient has. Sometimes, is it a temporary or a long-term incapacity that the patient has? Would some interventions change that outcome within the level of capacity for the patient? And do we need to, have we talked about that? Because sometimes when we're talking about jumping into the guardianship process too soon, we're too soon into the treatment path of the individual. If somebody is clearly has dementia, they're incapable, they have Alzheimer's, they're incapable of making decisions for themselves, there's no surrogate decision maker, it answers itself, right? You don't have to worry about that. But if somebody comes in because they have delirium because they're sick, and then what is it that at that juncture, will treatment for a day or two make a difference for them to be able to regain capacity to do that? So that's one of the things as a risk manager I'm asking about and I'm wanting to get an understanding of. And I think that one of the most important things is representations that less intrusive alternatives to guardianship have been examined. House Bill 1175, which I think it was in July of 2019 passed, which is the one that Keith was talking about, where it expanded the surrogate decision makers. Well, that's been wonderful in the realm of guardianship, because now you have a whole realm of other individuals that can step forward and make decisions in regard to healthcare decisions for their loved one, or it could be their friend. It doesn't do away with the dilemma that we have when people in the surrogate decision-making group, brothers and sisters or siblings, their children, they can't agree, right? So that doesn't eliminate that piece of it, but at least it expands the decision pool of people that can help intercede on behalf of the individual. And risk management's role with general counsel, it varies from hospital organization to hospital organization. Like at Swedish, the legal services, the legal affairs department helps to coordinate guardianships. But when I was at Valley, it was risk management department who we received the information from our social work team, and then we approved or disapproved, or we had dialogue in regard to obtaining the guardianship, and then we helped to facilitate getting the documentation that was necessary to proceed with the guardianship, to assign counsel, and then we continued to monitor that process and get involved as we needed to as that guardianship moved forward. And there were times when we initiated guardianships, like he talked about, and then all of a sudden the patient made a turnaround and they didn't need to have the guardianship. Or what happened is the surrogate decision maker popped up out of nowhere. They had a long lost child that showed up at the hospital, and then we didn't need the guardianship. So, you know, we would err on the side of getting the guardianship, and then we could dismiss it if we needed to do that. With us, we always try to maintain contact with the social work department to make sure that if there are any hiccups along the way, we can help to facilitate that. Now, some of the challenges that a risk manager faces in the guardianship process is, again, what I talked about is the lack of understanding when a guardianship is suitable. Due to the seriousness of the loss of individual rights, a guardianship should be considered as a last option and not the first option, which is why you want to look to see if there are alternative options available to you. And we should not be obtaining a guardianship if we object to lifestyle choices or have concerns about the living conditions of a patient. I once had somebody approach me for a guardianship because they had a dialogue with the patient, and the patient was spending all their resources from their Social Security at the casino. And they were saying, well, we really need to get a guardianship for this individual because I feel like they're, pilfering away all their money, and this is a danger to them. And I'm like, our role in the guardianship is based on the capacity for consent to be able to receive care, and also to help that individual be discharged or transferred to the level of care that they need. That's our role. If we have a concern about an individual that's not focused on that aspect of guardianship, then we need to call Adult Protective Services and make a report. And one of the things, too, I think it's really important to know that when there are circumstances where we have concerns about the safety of a patient, or maybe even that the patient is being taken advantage of financially or something, a guardianship that we initiate for our purposes does not take away our responsibility for mandatory reporting. It doesn't replace that. So while we're going on the guardianship path for what we need, we still need to, if we have concerns, make sure that we address that for that particular patient. And I find, too, that oftentimes there's a lack of understanding by our healthcare providers about the guardianship process. And I know that Keith talked about that, where people are confused about the guardian ad litem. They don't understand that it's a process that we have to go through, that we have to submit to the court, that we have, and that sometimes it can be a lengthy process, and it's not an overnight process necessarily that's going to give them the answer that they need immediately to be able to take care of the patient. And that's why it's important to recognize early when you have a situation where you are going to need a guardianship to act on it early, but making sure that we follow a process that allows us to make sure we have addressed any other alternatives that might be available to the patient. And again, as Heath was saying, there's a lack of understanding between the guardian ad litem and the guardian. The guardian ad litem is representing the interests of the patients in the court, but the guardian is the one who's going to be making decisions about the care. And I think that, that's the biggest confusion. Where when I was at Valley, I would have social workers and providers call me and say, well, we have the guardian ad litem, why are we not getting these decisions made? And then you have to explain to them that's not how that works. That's not the role of the individual. And I think my recommendation would be for organizations, if you don't already have standard work around your guardianship process, I think it makes the process smoother, more efficient, and it serves the patient better if you create standard work and define roles and responsibilities of who does what, and then making sure, like, for instance, when I was at Valley, our social workers submitted an SBAR to the risk management department that addressed all the key questions that we had. And once all those key questions were answered and we knew that we had it, we could just forward that on to legal counsel and say, this has been approved, please start the guardianship process. And before that, it was kind of a chaotic, disorganized process. But once we created that standard work, it really made a big difference in being able to very quickly and very smoothly get through the guardianship process. So I think that in conclusion, from a healthcare organization standpoint, clinical care always needs to reflect the wishes of our patients. And when a patient loses the ability to make those kinds of decisions and express their wishes, again, there's DPOAs, there's guardianships, but unfortunately, the challenge is that many of us are unprepared for our aging parents and our aging grandparents, and so we don't plan ahead until a crisis hits. And that's where the guardianship comes into play, and that's where, while it may be the option of last resort, it is often in the best interest of the patient for us to be able to have a system and a process that makes that happen efficiently and smoothly for the patient.
Great. So I'm going to open it up to some questions here. So let's see if the flute's still on. Give me 1 second here. All right, everyone should. And the flute is still on. If they're whoever's getting the massage, can you please keep your phone? Oh, there. I think we're good. Everyone's still. Hey, everyone's. Oh no, we're just turning to the next song here. Anyone have any questions here? Feel free to type it in the chat. Yeah. Sounds like a scary movie comment. Yes.
What's going the gap between hospital stays and either skilled nursing or assisted living for folks that aren't really ready to go home, but have elected to go home? I mean, they're not.
It depends. I think it depends on what they qualify for. It depends on their own resources. We have, if they qualify for home health, that would be a referral that would be made. You have to be homebound. There's certain criteria for that. That's intermittent. That's not every day. People can certainly hire a caregiver if they need to qualify through Medicaid or spend down to get a post-caregiver in the home. They can. We've paid for caregivers as a bridge to get somebody home so that they don't stay. We've done that. If they meet our charity criteria, we have we also have Dispatch Health is a new model that we have that is urgent care in the home. So physician assistant or ARNP and EMT go to the home. So there's a few things that we've been trying to do to address these issues, because otherwise they sit in the hospital.
Well, right.
Because the physician or care team is risk averse, worried about the discharge when it's tenuous, even if even when the patient has capacity and that's what they want. There's still some
they're
resistance.
going to err on the side of
Yes.
keeping there because the lawsuit then come. Well, she wasn't ready to be discharged and sent her.
Sometimes they're even ready to be discharged. Like there wouldn't be. Our legal counsel will say you're fine. That's it's not. I don't want to sound callous, but it's not a hospital's responsibility to solve the problem of someone who's elderly who lives alone.
Well, right.
It's about their medical needs, but we do. But because we know it's could be problematic, could lead to something later that could very normally have happened even if they hadn't been in the hospital. They could fall and home.
Well, it sounds like it's becoming your problem because because of the liability.
Right. Okay.
Right. Yeah. No, I always say my job is to keep the hospital off the front page of the paper.
Yeah.
Make sure the patients are safe, make sure things are, but keep them off the front page. Because it's a small town, there's one paper, and it's a problem.
Right.
So if you make the Seattle Times even worse.
Even worse.
Right. Well, I think the word safe has become part of a problem too, even in our own healthcare culture. The standard of care is reasonable, right?
Yeah,
But safe is very arbitrary.
Oh,
What
of
I
course.
think is a safe discharge, and the nurse standing next to me who wants to keep everybody in the hospital doesn't think it's a safe discharge, and so that we get trip up in that a lot as well.
Well, that's the word that plaintiffs' attorneys adore. It's this whole reptilian thing, but it's the standard of care for them is perfection,
Right.
and that's just impossible. And that's why I look at risk. Just thinking about your job stresses me out because by the time we see the litigation, the crack has already hit the fan.
Right.
And that's a much more comfortable place. We're sort of cleaning up. But you guys are tasked with avoiding risk and managing risk, and it just stresses me out. So kudos. Better you than me.
And we still need to address it because we are paying for it now, but eventually that's going to have to change. We can't keep paying for everything.
Right.
We're paying for placements. We're paying for a lot of things that we never paid for
Oh,
in the past. But $5,000 a month to put somebody in an adult family home is a lot less than what
Wow.
is happening for the person who spends 12 hours in the ED, and their mortality
Yeah.
risk
Yeah.
Increases after 3 hours, 6 hours, and so the opportunity cost for the 5 people who could have been in that bed that month.
Right.
Because our average length of stay is 4 to 5 days.
Well, you mentioned a charity fund or something. I mean, is that how it gets paid for?
Some of it depends. Sometimes the hospital pays for it.
Huh.
And that is there's a lot of rules around that in terms of
Of course.
compliance and things. There's only certain patients we can pay for, only certain things we can pay for, and that's all reviewed, and that goes through risk and legal too. So there's a lot of moving parts.
I kind of just wanted to follow up on that a little bit. And you talked about, one of the options is caregivers and more long-term homes for people. What sort of trends do you see with respect to the resources that are available upon discharge for a patient who's in that guardianship setting? It sounds like some of the long-term care resources are kind of declining due to funding issues. Is that also a trend that you're seeing in Eastern Washington? I guess is one question. And then in addition, kind of from the caregiver perspective, is that an area for potential for growth with increased funding or with increased training as a potential solution to the problem?
I think it is, and there has been some, the state home and community services and DSHS has been looking at that. They recognize the number of referrals they're getting for assessments for, the Medicaid waiver is really that funding. It's still Medicaid funding, but it's community-based funding. They've seen tremendous increase. They've also taken on the responsibility or the burden of helping with all the dispositions from Western State Hospital, and that's that same bucket of money is that Medicaid waiver fund. So we're seeing a lot more patients with behavioral health diagnoses in the ED because of failed placements in adult family homes from Western. So it's a huge problem. It's huge, and it's so many, like I said, so many moving parts. DSHS did, I think, increase the rates for adult family homes, increased some of the specialized rates for some of those other issues like behavioral issues, and then a little bit for the caregivers. When I have an individual with a developmental disability, maybe a young adult where the family is involved, the parents will tell me they have hundreds of hours of paid caregiving through folks, but they can't find caregivers that they trust. So there's just not a lot of high quality people that are going into that work.
Sure.
And so that's another barrier. So I don't see resources expanding even as money gets put in place. We have to rethink how we distribute the care and the services, because what we currently have right now isn't, I don't think it's going to meet the need.
And then here comes the tsunami.
Right. And the adult family homes are unionized. Does anybody know that? So the adult family homes are union, and what we've seen in Pierce County and South King County is they kind of get together. There's some plans about process, and we've seen an exponential increase in the number of adult family homeowners who will say, I'll take that individual, but I need an exceptional rate, I need an exceptional rule, which is another state process that goes all the way to Olympia. It's very cumbersome, it's not very lean, and it delays the discharge. And so they've gotten pretty savvy at doing it together so that everybody has to pursue that. So that's part of the challenge as well.
In Eastern Washington, we're in our towns, we have beds. We generally have beds where people can go to. The question is, can they afford it? You know, can I get the GAL to sign off on a Medicaid waiver or some other problem? Will the people actually agree to go? You know, is a problem. 2 cases I've had in the last couple of years have involved people who are in this country without documentation, who are immigrants from whichever country, who either came here well and became injured such that they need skilled facilities, or came here injured, basically, and then ended up in acute settings. And now, how do I get them out of the hospital without documentation or with some documentation? And how long before they get it? And how long will my hospital have to pay to house and care for these people? So, yeah. And what kind of waivers? Like, I have one who is DDA eligible, but not for a core waiver. So, which means there's no funding. So, yeah. So we've been, and with the OPG funding coming, hopefully we'll be able to work on some situation for that lady. But that just means that OPG is paying the Guardian. That doesn't mean they're going to pay for the housing that she needs and the 24-hour care she needs. So it's a big challenge.
I think there are 45 skilled beds funded by Alien Emergent Medicine in the state.
Wow.
In the state.
Wow.
So not my health system, but a colleague of mine in another health system, they paid for a skilled nursing bed for 2 years for a person who's not a citizen without documentation until he got into one of the funded beds.
Right.
And that was still $250,000, and
Right.
it's still less costly than it would have been to maintain him in the hospital.
Well, yeah, absolutely.
Sure.
Yeah, when I tell OPG, you know, what the hospital's going to have to pay, she almost falls over. And I said, well, but that's still cheaper than having her take up a med-surg bed, which means that the people in the ED aren't getting in. Yeah, who need it.
Yeah, the country of origin really matters.
Yeah. Yeah, and I
You
do
can
have,
work with some foreign consulates. but-
and some not. I have a friend who works in the State Department. She says, okay, I know people in these countries, but if they're from another country, then it's kind of a challenge. So, yeah.
Wow.
So I need friends everywhere.
No other questions here. Thank you, everyone.
Thank
Appreciate it.
you.
Thank you.
Thank you.